Hello and welcome to One and All. My name is Lakshaya and I'm an intern at LEXIS and Co. I'm a third year law student at New Law College, Pune, and the topic for the day is fundamental right to marriage and LGBTQ movement in India. Decriminalization of 377 section by Supreme Court of India in the case of Navtej Singh over the Union of India, which is carnal intercourse against the course of nature between consenting adults, will no longer be termed as criminal offence, was a great win in terms of decriminalization. This was a huge leap towards recognizing and acknowledging the existence of homosexual couples, but this only constitutes the bare minimum. Recognizing a small part of a very large population is a small step, but depriving them of the basic fundamental rights is just cruel. To actually welcome the queer couples and let go of the decriminalization, we have to first welcome the idea of same-sex marriage. This will provide them with the same footing as that of the heterosexual couples, despite being mentioned in the Constitution that every citizen has the right to choose their own partner and marry. In Article 21, homosexual marriages are blatantly denied in India. The marriage is when two people come together and are legally, socially sanctioned, regulated by laws, beliefs, customs, rules, and attitudes which will be prescribed the rights and duties of the partners. This is what marriage is supposed to mean. Although it is very common that a man and a woman get wedded, but with the change in times, these old customs need a fine-tuning too. Although it has not been expressly mentioned that homosexual marriages are prohibited, but the homosexual couples do not receive the same rights and recognitions under the purview of law. As we all have made it pretty clear from the above, heterosexual couples are given the fundamental right of being married and being recognized, whereas the same is not the case with homosexual couples, even though they have been recognized in the Navtej Singh case. This is like denying an entire class from their birthright, which is guaranteed to every citizen of India. It is well-established legal principle that to qualify as a reasonable classification and thus not in violation of Article 14 of the Constitution, right to equality. Two tests must be met. First is the classification must be based on intelligible differentia, and second is differentia must have a rational nexus to the legislative goal. All the acts which govern the marriage focus on nothing but citizens of a caste in or outside India and the consent of both the parties, and make sure that nothing is illegal. All of this checks out, and still homosexual couples are not allowed to be legally recognized. This is a serious disruption of fundamental rights. With that being said, it is about time for the Indian judiciary to make way for the LGBTQIA plus community, as it will provide them an equal stand with the rest of the community and not be in clear disruption of fundamental rights. To fulfill this, there are three things which can be done. First is changing India's existing marriage rules to make them gender neutral. Second, making specific arrangements for same-sex marriage and the Special Marriage Act of 1954. Third, creating a new law that recognizes and regulates same-gender marriages. That is all. Thank you and have a great day.